This is Eitan Weinstein.
And I'm Naor Menninger, and you're listening to Two Nice Jewish Boys.
Not long ago, the biggest story in Israel was the tidal wave of protests against the government's proposed judicial reforms. Week after week, hundreds of thousands flooded the streets, warning that the very foundations of Israeli democracy were under threat. The demonstrations reflected a moment of bitter internal division. Then came October 7th, and everything changed. The country shifted overnight from bitter internal division to all-out war. But while the fighting continues and the hostages remain in Gaza, the internal battles are slowly resurfacing, this time with even higher stakes. In the latest twist, Prime Minister Netanyahu fired Shin Bet chief Ronen Bar. Now he's in the process of interviewing replacements. By law, the Prime Minister can fire the head of the Shin Bet with the government's approval, of course. But that hasn't stopped the Attorney General from objecting and the Supreme Court from freezing the decision. For many Israelis, this isn't just a legal question, it's a test of who really holds power in the country. And for those who watch the judicial reform protest with concern, it's a reminder that the battle over Israel's institutions is far from over. So to help us unpack all of this, we're joined today by Professor Talia Einhorn, a leading expert of Israeli constitutional law. She's a member of the Advisory Committee on Senior Civil Servant Appointments and a titular member of the International Academy of Comparative Law. She's held academic posts at Ariel University, Tel Aviv University, and institutions around the world, and she holds many other distinctions in the legal field. Today, she's here to walk us through the legal drama, the deeper power struggle, and what it all means for Israel's future. We are thrilled to be joined today by Professor Talia Einhorn. Thank you so much for joining us. How are you?
Thank you so much for having me today.
Just to clarify, Shin Bet is the equivalent
FBI.
of FBI in Israel. So where do we start from? We had last week Aharon Barak, the legendary retired head of the Supreme Court. What some consider him the biggest judicial mind of our generations, and others say he's the father of the, let's say, legislative coup that we had in the 90s. Depends who you ask. And he went on an interview and basically said that the laws that they're passing now and what they're going to do with the Shin Bet, firing the Shin Bet, the law that they're going to pass about the committee to elect judges and all those will lead to a civil war, according to him. How do you see that interview and what he said?
Well, first of all, he came on, he gave interviews to three channels. Channel 14 was a distinct exception.
Mm-hmm. 14 is the equivalent of Fox, let's say.
And 11, 12, 13, the public national television, so to speak. And the immediate cause was the firing of the head of the director of the General Security Services, the Shin Bet, as you said. And he said that to fire him was, this decision could not be upheld, even though there had been a petition to the Supreme Court. The Supreme Court, as you said, suspended the termination of his appointment, but allowed the government later on, nonetheless, to the Prime Minister to interview his substitutes, the followers. And Barak said that had he been at justice at the court at this time, he would have canceled the termination of the appointment. He had not even heard the pleadings of the government, which had not yet been submitted at all. So he had already formed his mind. In fact, he told the court how it should decide such a case.
Some would say dog whistled.
And even worse, he said that if the government continues with the termination of this appointment, that would lead to bloodshed and civil war. Now, these are very, very harsh words which may lead to action, and that is unacceptable. I mean, according to law, it is within the full power of the prime minister and the government to terminate for any reason whatsoever. And this has been made abundantly clear when the GSS bill, the General Security Services bill, was adopted into law by the Knesset, even by a telephone call telling the head of the GSS that his term is over. So it is completely unacceptable. It's a way of creating anarchy in Israel for no good reason whatsoever.
So is the Supreme Court, let's start from the basics here. Is the Supreme Court allowed, or is there a legal base for the Supreme Court to discuss or to rule on this matter, on the government's right to appoint or fire the head of Shin Bet?
Well, this goes back, your question, which is very pertinent, goes back to the legal revolution, constitutional revolution made by Aharon Barak years ago. And what did it consist of? Aharon Barak said, first of all, one should explain that the Israeli Supreme Court, sitting as a high court of justice in administrative and constitutional matters, is a very unique institution. It sits as a first and last instance. It doesn't hear evidence, and it decides according to affidavits. And you cannot even take the person who gave the affidavit, put him on the witness stand, and cross-examine him to make sure that what he said in his affidavit is correct.
Also, it's worth mentioning that it sits as a kind of a constitutional court, even though we don't really have a constitution.
We don't have a constitution, yes, but one step by one by one. So
I think it's important, though, to highlight that.
Of course, we shall.
What you just said, the Supreme Court does no evidentiary investigation, meaning they don't try and find evidence, and they can't cross-examine witnesses. They only read testimonies.
The lawyers cannot even cross-examine. We have an adversary system. So in principle, the lawyer for either the plaintiff or the state should be able to cross-examine the person who made the affidavit. Nothing like that.
So they read the case, the lawyers make their claims, and then they make a decision?
Yeah. And often
wow,
it happens that these decisions have no basis in fact, unfortunately. So this is one problem of our legal system, so to speak. But when I was a young lawyer, at least there were certain limitations to petitioning the Supreme Court, the High Court of Justice. You had to be directly and personally affected.
Standing.
So that was a matter of standing, indeed. Not every person could come to the court. Not every public petitioner who represents no public at all could come to the court and complain about something. So there were certain rules to this game. That was number one. Number two, there were questions that were considered not justiciable. You couldn't bring any problem. You couldn't petition the economic policy, the security policy, and so on and so forth. You couldn't come to court and say, well, I don't like this, what the government is doing. There is some inequality there to somebody. Of course, whatever the government does, whichever policy, it often comes to promote a certain group or a certain idea and so on. And the only way to carry out the policy is by providing certain preferences. Now, as soon as you pretend that there is such a rule of total equality, that every measure that the government takes must meet some kind of full equality, that's the end of the government's ability to govern. No governability whatsoever. So these were two big problems of the court. Thirdly, when I started as a lawyer, you there was a cause of that the government's act was unreasonable, but it had to be unreasonable in the sense accepted in America or in England, meaning Wednesbury reasonableness, meaning that no public authority would have taken such a measure, even though within its power, it's so unreasonable that it would have been inconceivable for any public authority to take this measure. For instance, one morning I woke up in my home in Ramat Aviv, my apartment in Ramat Aviv, and all the streets were covered with red and white.
Parking. Not. You're not
You
allowed to
couldn't
park in Tel
anywhere
Aviv.
in Ramat Aviv. In my neighborhood, you couldn't. I think they heard at the municipality building everybody screaming. So after a couple of days, they changed it back.
It's a real example.
Yeah, it's
okay,
a real
okay.
example. No,
One morning you woke up because in Tel Aviv, if the sidewalk is blue and white, you can park. And if it's red and white, you're not allowed, and you'll be towed. Your car will be towed. So
in principle, of course, the municipality has the power to.
So one morning you woke up and it was all painted red and white.
Yes.
So that's unreasonable.
So
okay.
And then they gave tickets?
Well, I
Like
don't
they painted
know.
it red and white and then gave a ticket to the car that's parked there?
I don't know.
Okay.
I was just driving.
Because I've heard stories like that, where they come by, they paint it red and white,
Yes.
and then the
By
pakachim
the-
come through and give a ticket.
I've seen that too, but I have never seen a whole neighborhood painted
Red and white.
red and white.
So that's unreasonable.
So
what's
that's unreasonable.
the Israeli version of
But the
unreasonable?
Israeli version became like what's unreasonable in the eye of the beholder.
The
If
reasonable man.
it's unreasonable,
Who is the
if-
unreasonable man?
Of course, it's the
old
judge.
Ashkenazi, leftist. That's the reasonable
Who's-
man, right?
And if it is contrary to his values, then it becomes unreasonable in the eye of the court. And the court may hold it unreasonable. By the way, within the reform, the only thing they managed to pass was an attempt, a law was adopted, to abolish this unreasonable test. Of course, there are many others. There is excess of power, not taking account of pertinent considerations, taking account of considerations that shouldn't be taken account of. There are many, many causes of action in administrative law, even proportionality, which requires some kind of measures, but not just if it's unreasonable in the eye of the beholder.
But that point is important because they legislated, this is the only law in the reform that was passed, and then it got to the Supreme Court, and they...
And the Supreme Court then said, well, sorry, fellows, it's unconstitutional for whatever it means. Of course, and we must remember that it's now the decision of the court was taken by 6-5. So it was, how should I say
Close
it?
call.
A close call. But now comes another point in this judicial revolution, so to speak, of Aaron Barak. In 1993, he also decided that the decisions of the Attorney General, who is the legal advisor to the government, are binding on the government. Until that point in time, it was clear that the advice of the Attorney General is, as it is called, advice.
Yeah,
That's
it's important to note that in Hebrew, the name of the Attorney General is the advisor.
The
the
legal
government.
advisor.
Literally the advisor.
Yes. So his advisor. Now, there was a committee chaired by, there had been a committee in 1962. There was a committee chaired by the president of the Israel Supreme Court, former President Shimon Agranat. And that committee said, no, the advice is only advice, an advice. It's not binding on the government. The government should read it seriously, take it into consideration, but the government is free to decide otherwise. Aaron Barak, when he wrote his decision, he wrote that in Israel, according to the decision of the Agranat Committee, which said exactly the opposite, it has become a legal tradition, a constitutional tradition, that the advice of the Attorney General is binding on the government, and the government must follow it unless the Supreme Court decides otherwise. Now,
But this is all legal precedent, meaning there's no law in Israeli law
Regulating.
that
regulates
requires
the position of the Attorney General. No, there is no such law. And in fact, it is contrary to
common sense.
exactly. If we
The
may use
reasonable
this
man.
term. Yes,
Wouldn't,
indeed. Now, it's even worse because in Israel, the Attorney General is also the head of the prosecution. So the Prime Minister and the ministers are aware that if they don't follow his kind advice, which is anyway binding, he may investigate them. And these things have happened in Israel when the Attorney General doesn't like the Prime Minister very much. Yeah,
Conflict of interest much?
the way is open, the road is open. We know how Mr. Mandelblit, in his own voice, said that he was pressured to indict Prime Minister Netanyahu.
Not pressured. He says he was blackmailed.
Yes. Well, that's
It's a type of pressure.
Yeah,
It's
that's
some
what he
kind of
says on the record.
Yeah.
I was blackmailed to do it. Yeah.
Yeah.
But back to the Shin Bet and back to the
Yes.
question. So because there is no law that says that the Supreme Court can, there is a law. There is a law that says
No,
that
there
the
is a
Supreme
clear law.
Court is allowed to intervene with the decisions of the not the legislative, the
Government.
the governmental branch.
Yeah.
It is in executive branch.
Yes. But
They are allowed to tell the executive branch to not do anything that they see fit. No,
Well, there should be.
we're in an echo chamber here, so I have
Yeah,
to.
yeah. No, that's
We all think
perfectly
alike,
okay.
so we have to-
No,
yeah.
the only problem is that there must be a cause of action. You can't just come to the court. Moreover, it has been a rule since many, many years that if somebody was personally and directly affected, he should bring the petition to the Supreme Court, not anybody else.
Right.
In this case, the head of the general,
Ronen Bar.
Ronen Bar, the director of the General Security Services, he may have had the right to petition the Supreme Court. Even here, he would have had a problem because the law is very clear in this case, and there is also an explanatory note, and there were the discussions within the Knesset when this rule was adopted. So it was made very, very clear that the government has full powers to terminate his position. There is no question about that. But in this case, he didn't even petition the court. So we have public petitioners, public in their own eyes because they represent no public whatsoever. And they go to the court. And then the court, without any basis, instead of sending them home, dear persons, what are you doing here? What's the basis in the law for your petition? And it's not that the court doesn't know how to do such things when they don't like certain petitions. And in this case, there was no ground whatsoever to even accept it to a hearing. They accepted it. They suspended the termination of office. And they also required the government to provide answers. So
what does it mean?
That there will be a hearing. And now it depends. Now, moreover, the Attorney General sides with the petitioners.
Mm-hmm.
But that is another peculiarity of the Israeli legal system. The Attorney General in Israel has a monopoly over representing the government before the court.
Mm-hmm.
And she may or may not allow the government even to be represented. So we have had cases in which the government was not represented at all. Only the Attorney General, who supposedly represents the public interest, whatever you may understand with that term. So it's only the Attorney General who tells the court what the law may be. The Attorney General may side with the petitioners. In this case of the Ronen Bar, the Attorney General very kindly allowed the government to hire a private lawyer. So Mr. David Petel, who is an excellent attorney and will surely make a wonderful representation. No, it was Tzion Amir.
Tzion Amir, yes.
Also
a
an
good,
excellent
yeah.
choice. And he will represent the government. But what kind of a system is that?
Mhm.
I mean, we've had cases where the government of Israel was not represented at all, meaning that the government, the prime minister, the ministers, may have less of a standing in court than a terrorist. Think about that.
Mhm.
How is that possible?
Unbelievable.
So coming back to Aharon Barak, what he did, in fact, Professor Richard Posner correctly called him legal pirate, meaning that he hijacked the legal system. He arrogated to the court powers that it has never had before. And even worse than that, he created anarchy in the whole legal system. It's not only constitutional law and administrative law, it's also private law. Now, civil law is the economic constitution of a liberal society. So let's say in contract law, people should have autonomy to decide whatever they want. They make the rules for themselves. Nonetheless, Aharon Barak held in a case between contractors and the state. As it turned out, the state made a deal that wasn't great for the state. So Aharon Barak said, well, the contract should be interpreted according to the way it would have been drafted had it been drafted by reasonable business people. Now, who are the reasonable business people?
Trump.
No.
The best
They
deal
are
maker.
the justices, of course, themselves of the
Yeah.
court, the judges of the court.
Right.
That was number one problem. In another case, he decided that in addition to all remedies given in the contract law, which are very clear, so the rules of the game are set in the law as well, he decided that you could also have remedies in unjust enrichment. The problem is that unjust enrichment is another field of civil law in which the remedies are given at the discretion of the court. And the court also measures the good faith of the parties. So the result is that instead of saying, okay, this party was in breach, broke the contract, the other party deserves to get the remedies under the law of contracts with unjustified enrichment, the court has discretion to check whether this party or that party acted in good faith, a question that opens everything completely to discretion, and then it affects all other remedies. So
it sounds like they're kind of injecting these terms that are very vague, like reasonableness, or even taking them from common law, like reasonableness and unjust enrichment, and good faith, and then kind of using them to really expand their auspices.
Even
their
worse,
power.
because we say that we took the good faith principle from German law, except that in German law, if you look at the decisions of the Bundesgerichtshof, the German Supreme Court, you would see that it features in very few cases, less than 5%, and they're only in one sentence. By doing so and so, let's say, I'll give you an example. Normally, the plaintiff has to prove his case. But what do you do if the defendant has all the evidence in his hands and nonetheless he says, well, let the plaintiff prove? So the Supreme Court in that case said that the insistence of the defendant that the plaintiff prove his case, and while he has all the evidence in his hands, is against the principle of good faith. That's all.
I see. And
so
here in Israel,
in Israel, a German court would never put on the scale the good faith of this party and that party.
How often is it used here?
Well,
in Israel?
I once made a study 25 years after this famous case, and I discovered that how do you call it? Minutes are taken, but hours are lost. Days, sessions are lost over figuring out which of the
Deliberating.
parties was really in good or bad faith. And moreover, sometimes when both parties are business people, guess what? The court comes to the sad conclusion that both parties were not exactly in good faith. And then suppose you have to return...
Who's less in good faith?
Suppose there is a remedy of restitution. So in such a case, maybe restitution will not be given completely, but 30%, 50%.
It's unbelievable.
Goes. And at the end of the day, according to a study carried out by a report of the World Bank, based upon data from 2019, in Israel it takes 975 days on the average to enforce a contract in court.
Wow.
On average.
Wow.
Yes, and
unbelievable.
this is the main problem.
Yeah.
This is a
And
serious problem.
I think the everyday citizen in Israel feels it in the sense that everybody
Trickles down.
is dead scared of getting to court because they know it's going to take years and years and years, and no one has a lot of confidence or a lot of faith in the contracts that they sign, because ultimately you know that when you get to court, it's not really going to be what's written in the contract.
Yep. That's so. Instead of we had how should I say it, a legal system, a young legal system. Of course, it needed improvements. Instead, we have lost the sense of a system. It's no longer a system. Now, let's take criminal procedure. Here, this is really the realm of civil rights. I mean, you expect the proceedings, at least the procedure, to be fair. Nothing like that. And in these matters, I mean, in Israel, okay, we have an adversary system, which is great. It has great advantages when you want to prove something. So you have an examination, a principal examination, a cross-examination. And this is probably the best way to discover the truth. Now, we took that system as it is in common legal systems with one small change. We don't have a jury. We don't have juries sitting in criminal courts. Now,
unlike other British colonies,
all states that have this common law system have a jury trial, a right to of the accused to a jury trial.
What does that mean? All the
New
old
Zealand,
British
Australia,
colonies,
except for India and us.
Now, coming back, I never thought that a jury system is really fantastic, except for one thing. It limits the time in court. You cannot keep the jury for 5, 6, 7 years or more. Now, the problem, so the prosecution that has all the funds of the state can use its resources to keep a person on trial for years. Let's take for a very important example is the case of Prime Minister Netanyahu. The prosecution part has taken by now 5 years. Only now we start to hear the defendant, the indicted. Insane. Now, how many people have the resources to keep going like that? Yeah. You have to finance a lawyer.
It's millions and millions of...
you don't have the money. And we're even worse. The court doesn't really care too much about the rights of the indicted person or of people accused or brought to investigations and so on. Their rights are often not respected. We've seen cases, and we've seen many cases in which the investigators have been lying to the persons they were interrogating. They tortured them to get out of them a confession. They used, like NSO, these spyware in order to find out things about their personal lives, and this way extort from them confessions in other matters
Yeah, they go
If
to
they-
search to fishing expeditions, basically.
But
because,
I want to.
And the court
Yeah,
doesn't hear help. It's not there. The court could have said that such behavior is unacceptable. And in fact, even maybe the prosecutors or the investigators should be
held accountable.
held accountable. Nothing like that happened. And here you never heard the voice of Aaron Barak. He is supposed to be the great protector of basic human rights. But in these matters, we haven't heard his voice at all. And the current president of the court, who appointed himself to become president, that's another story, Mr. Yitzhak Amit, said a while ago that he doesn't understand all these speeches of rights. There are too many rights to the indicted. That's not true. In Israel, 97.5, I think, percent of the persons indicted are convicted. So this doesn't say very much for our system, or if you can call it a system anymore at all.
I want to get back to finish the discussion about the Shin Bet, the head of Shin Bet, Ronen Bar. And I want to ask you two questions. First of all, what does it mean legally, judicially, constitutionally, if eventually the Supreme Court decides that the government is not allowed to fire Ronen Bar? Okay. What does it mean?
It means very simply that the court does not consider itself bound by the rule of law. Because in a legal system, the idea of the principle of the rule of law doesn't mean that the three of us are bound by the rule of law. It means first and foremost that all the executive, the parliament, and also the judiciary are bound by the rule of law. Everybody, every institution must be bound by the rule of law.
And the law, it's important to say, is not what the court orders.
Interprets.
It's not what the court orders or what the court says. It's what's written in the books of law.
Which, by the way, the Shin Bet law, we didn't talk about it. It's a new law. It's a law from 2002. Which is also pretty scary to think what was, how did the Shin Bet operate until 2002?
There are books about it. There's literature. You can find the answers.
Yeah, only in 2002 they legislated it, and so it's really new, and they made it abundantly clear what are the rules of the game with the Shin Bet. So it's very hard to say.
Yeah.
And the law says explicitly, like there's a whole article that just says the government is allowed to remove the head of Shin Bet.
You know,
Yeah.
you remind me that in one of the most recent cases, the precedents were cited to the court, and Mr. Amit said, well, you know, a lot of water has gone down the Yalkon since these decisions were made. I mean, these were the precedents, they were binding until now. And not,
But now to the bigger
well,
question.
Go ahead.
The bigger question is because most of what you explained now,
Yeah.
we already discussed because we did an episode in 2019, which in retrospect was a bit
jumping the gun.
Foreshadowing.
and prophetic. How do you say
Foreshadowing, yeah.
to the whole
problems were
judicial
there
crisis
already.
we had, and we even
Yeah.
had talked about it. And I asked you, and I asked you what happens if the Supreme Court will rule out a basic law made by the government, and you said, I hope we won't get to that, and we reached that. So, but in the end of the day, and here I have some criticism towards you, because the people went in 2022 and voted for this government with an unprecedented majority.
Yeah.
Okay, so there was a huge consensus, a huge mandate from the people to this government to fix those issues.
Yeah.
And they failed. They simply failed. Like,
Correct.
they had one job to fix those problems. And in the end, we know what happened. There was the riots and the demonstrations and but in the end of the day,
They failed.
they failed miserably. So where is your criticism against that?
Well, you said that was their main goal or their only goal of the government.
One of their main mandates.
The problem in Israel is that the government has many issues to solve. And it's true. So sometimes also, it's true that a majority of the population voted for this government, a clear majority. At the same time, people became scared. They were brainwashed. They were told that that would be the end of democracy, no matter what. And this was incorrect, but nonetheless, people became scared. I think what changed, in my opinion, was the October 7. Because, I mean, first of all, we had the opposition was not, maybe did not represent, I'm sorry, the opposition to the reform did not represent the majority of the population, but it was a very mighty opposition. They said, we have the money, we have the resources, we have the army, we have the judiciary, we have the universities, we have everything. We have the media. So you may go on, but that will be the end of Israeli democracy, so to speak, if that's called democracy. And indeed, the worst thing was the people who said that they would not serve in the army if the reform passes. And this was unfortunately also taken by our enemies. They took it very seriously. They believed them.
So it was an opportunity. But it was a bluff in retrospect.
Yes.
It was a bluff.
But,
and we bought to the bluff.
And therefore, I'm coming back to that. I think now there is a much larger percentage of the population that understands that the reform is necessary. Before the elections, people wanted it, but they didn't understand how important it was. But I think we see now, yes, there is a protest again, but not so many people take part in it any longer.
Mm-hmm.
So
I'm not so sure that, because I don't see the judicial reform on the docket, meaning right now there's protests against the firing of the Shin Bet, which is a singular action. But if the reform is brought back to the table, I'm not so sure, because I think that I agree with your analysis, and I think that, but ultimately I think the government is to blame that they didn't react accordingly. They weren't steadfast in their reformation of the judiciary in the face of a very, very mighty and vocal minority. But what I'm saying is that now it's easy to spin it the other way. It's easy to say we saw what this judicial reform did to us the first time. We can't do it again.
My answer would be the following. You see, when previously Aaron Barak said, when there is eventually a constitutional how shall I say put it? Clash. The question will be who the tanks will obey. Will they obey the Supreme Court or will they obey the government? I think this question has been answered with the termination of the term of the former chief of staff. The current chief of staff made it very clear that he is subject to the government's decision, which is also what the law says. I mean, the law in Israel is very clear that the Israeli army has to accept its orders from the government, not from the court. So this is one thing. So we don't need to worry anymore whether the tanks will have to obey one side or the other. This matter has been settled. With the termination of the appointment, I see your doubts, but with the termination of the appointment of this director of the General Security Services, Mr. Ronen Bar, who clearly defies the authority of the government. In the letter, he wrote a letter to the government saying, hey, I don't listen to you at all. I'm not subject to your orders. As soon as he is replaced, and I'm pretty sure that he will be, then that's another thing. In a country in which the security services, the army, the government, the police, consider themselves unbound by decisions of the government, is not a democracy. And therefore, I believe that things we are an impatient people. Yes, we like to see the results coming as they should immediately. But we did have a problem here. And the problem was that also the police, you could see it. I mean, these protests, some of them were completely illegal. And there was nobody to take care of that. Quite the contrary. The head of the police in Tel Aviv walked hand in hand with the protesters who set fire to the highway, who damaged private property, and behaved in ways that would not have been allowed to any other sector of the population. The police wasn't there. So now, once you have the police, the general security services, and the army understanding their position in a democracy, that changes very much, as well as the public understanding that this cannot be upheld any longer.
I have a question.
Yeah.
The first back in 2023, when when the judicial reform was being attempted to be passed, was it prolonged? Was the time that the government was taking and the Knesset was taking to pass the law through, was that longer than a normal law? Was it shorter? Could they have done it quicker? Like, I'm wondering if it was if that's just part of the narrative that they stretched it out, or if they were just going through the process as they needed to.
Well, since I followed this reform very closely, I was deeply interested in it, and I came to almost every session of the Knesset Constitutional Legislation Committee. So I can tell you that discussions in the Knesset were very serious. I mean, the media would come in for a few minutes when there was noise in the committee and just film those and leave immediately after. But the discussions were very serious, and changes were introduced in the course of the debates, Knesset debates, to try to make a reform that would be acceptable. Towards the end, I was invited to a conference at Columbia University, and there I explained the need for the change in the Judiciary Appointment Committee and the role of the Attorney General. And people understood there that this made sense. And in fact, also Alan Dershowitz, who, listening to the chair of the committee, Legislation Committee, Simcha Rotman, said, well, this change makes sense. So it wasn't like they didn't take the decision entirely out of the hands of the judges, but they try to find some kind of a balance. Now, to try to strike a balance takes time. And some of the sessions went until late at night. I would come back at 1:00 in the morning back to Tel Aviv. So it wasn't really like dragging anything.
No, my question is, could it have been faster?
It's very difficult to tell. I mean,
the whole process of legislating in Israel is slow by definition.
Because I remember hearing statistics back then that like Simcha Rotman had heard more than any other law, or had heard opposing arguments, or held more sessions. I don't know if it was true or not, but the question is, could it have been faster? Because I think in retrospect, my criticism, and maybe it's unjustified, is instead of just doing what they were voted to do, instead of just passing this law and not caring so much about striking a balance, but just, making some changes as needed and then getting the law through, they dragged it on. They pandered and appeased the protesters and the left and the opposition. And in the end, it led us to the place that we're in.
I'll give you an example. There was a law passed about taxing a third apartment. Whether it was clever or not is a different question. But the Supreme Court set aside this law because it held that the Knesset didn't debate it long enough. Didn't take all considerations into account. It was too hasty in adopting it. So here the court might have intervened, saying, not that the court sometimes decides on the spur of a moment, some cases, yeah. But what is allowed to the court is not allowed to the Knesset. Now, the Knesset procedure, it takes time. Look, for instance, at the draft law. How many sessions had been spent on the question of the draft law? And even when the Knesset struck a compromise, which would have been pretty much okay for that time, the court set it aside. So you're trying not only to appease the left, but also to come with something that the court will not set aside. And because it has to be
Yeah, but it was
admitted.
clear that the court was going to set aside this law. I mean, we didn't imagine that we'd pass the judicial reform and the court would be like, okay, you obviously did what you needed here and we accept this.
Yes.
They were gonna,
And by the
they
way,
were gonna
when the
object to
Supreme-
it to begin with.
When they ruled out the Reasonability Act,
Yeah.
we didn't we didn't do anything about it.
And I'm
since.
wondering, but what I'm,
Because at that point in time, it was impossible already to deal with these
Yeah.
problems.
but I think there's another issue with the system, which I think you pointed out with the
Non-system.
proceedings.
Yes.
With the fact that they carry out for years and years. There's an idea in high tech where I come from about fast iterations. You do quick changes, you learn from them, and then you improve on them. And you do it over and over and over again. And that's the best way because perfect is the enemy of good. So you know you're going to make a mistake. So I wonder if maybe we need a system that is more decisive, passes laws quickly, or changes laws, right? I don't want more laws, but makes the changes necessary. If they make a mistake, they require the coalition they say, you know what, this is what we're here to do. Vote, don't vote, then we'll break up the government and then we'll get a vote again.
You have a Jewish coalition. So first of all, two people, the different parts of the coalition must agree upon the way to go forward. Sometimes they don't agree. What do you do then, you see? Because the coalition in Israel is always fragile to an extent. Not so easy. Secondly, the former government did things at the spur of the moment and there was nobody to stop them. They wanted to hand over territorial, they didn't only want, they handed over territorial water and economic water without coming to the Knesset in defiance of a basic law that says that unless you have 80 Knesset members to support such a move, you need to have a referendum. And this was even approved by the High Court
And
of
look,
Justice. No
they
problem
succeeded
whatsoever.
Beautifully.
Well, I wouldn't call it beautifully because
For
they
them.
pretended, not even for them, not for anybody, because eventually we were told that unless this chunk of land is given to Lebanon, in fact to Hezbollah, unless then we'll have a war. So eventually we had both.
Yeah.
We gave it up. We gave up the land. And even Lebanon didn't want to sign it against Israel. It was deposited only with the signature of Israel with the United Nations.
If the Supreme Court eventually decided to not allow the firing of Ronen Bar, what then should a government do in that scenario?
Fortunately, I'm not the legal advisor to the government in this matter. Look,
That would be a real constitutional crisis.
that would be a real constitutional crisis. That's correct.
We never reached that close, right? We always got close, but we never reached to a point where, the Supreme Court
Well,
actually...
let's hope that we don't reach it then, because this will mean, in fact, that the court doesn't care at all about... it doesn't consider itself at all bound by the rule of law.
Yeah.
And the court is aware of that.
What
Because
would you say though should be the action of the government in that case? Meaning if the Supreme Court knocks it down, says you can't fire.
Or in the case of the Yoetzet HaMishpatit, the advisor, let's take a more...
this will come immediately afterwards. Right. These things will require a change. And I'm sure that the change, I don't know what will happen at that given moment, but I'm absolutely sure about one thing, that this will not be upheld for long.
Mm-hmm.
This will change. And, where do I take my optimism from? When I was a child, we didn't have problems of, it was before 67. So the difference between right and left in Israel was the questions of the economy, a liberal economy or an economy held in its neck by the trade union, by the Histadrut. And the Histadrut was very strong. People couldn't get a job if they weren't members and so on. We know it. My father used to tell me, you will see this balloon explode. We're not yet. We are no longer there. Things have changed dramatically. So it may take a little bit more time and so on, but this balloon will explode. This kind of legal system cannot be upheld. And the Israeli people are clever enough to know and appreciate that. So this will not be upheld.
Yeah, but balloons can explode nicely and quiet, or not quietly, but on the side, and they can explode in your face. I'm just hoping that it'll be the former and not the latter.
It will be the former because people, fortunately, we still have elections.
Yeah.
And as long as we have elections, look, it's one of the strangest things that before each election, we see the polls, and the polls regularly show that the left
will be
is winning.
Yeah.
And then come the election results, and it goes the other way around.
Yeah.
Surprise.
So I'm confident that the people of Israel are clever enough, and they will change. This system cannot be upheld for long.
I want to talk a few minutes about the war in Gaza.
Yeah.
Because you're also very knowledgeable about international law. And even now, there's a lot of discussion there we saw for the last 1.5 years about Israel. Is Israel committing war crimes in Gaza? So to put it simply, is Israel committing war crimes in Gaza? Is it? And if so, what? No? How so?
How so? Look, since the beginning of the war, I've become an ardent reader of the United States Department of Defense Law of War Manual, 1,250 pages. And
War and Peace.
And it has war in one big piece. Now, it has answers there for every problem that we encounter. And I wish that the Israeli army had followed the rules there, because what is happening in reality in Israel is that the prosecutors of the army and the lawyers for the army are tying the hands of the soldiers in ways that do not exist in any country. And this has been said time and again also by people like Colonel Richard Kemp, who was the head of the commander of the forces in NATO forces in Iraq. He was in Afghanistan. So, I mean, people like him say, and that's correct, that the Israeli army really considers itself much more bound by the rule of law, even inventing rules that don't exist at all to protect the lives of the enemy. And indeed, I mean, look at what happened. Also, the Hamas has obligations under the laws of war. It has to separate the civilian population from the people in combat, and they don't do it. Quite the contrary. They hold them. This is a war crime, to hold people as human shields. That's the fact that they take I should say that according to the laws of war, Israel would have been allowed to put a siege on Gaza and demand the return of our hostages. And a siege is held also as more humane than other means of war, simply because it would have brought the other side to surrender.
But what kind of
at less
siege?
cost.
We're allowed to prevent water and food from civilian population?
Yes, because otherwise it's not a siege, it's a dam with a hole in it. And it's not worth anything. Of course, you're not allowed to put a siege only on the civilian population, but it should have been up to Hamas to separate. Instead,
if the military
and indeed,
embeds itself in
the
civilian
first
population.
100 hostages that we got back from Gaza were thanks to the siege that Israel had imposed at that time. At that time, 2 trucks were given were coming in with humanitarian aid. Unfortunately, for Israel, the Biden administration pressured Israel to give up the siege and to
they made their own siege on us.
Yes, and also an embargo on weapons and so on and so forth.
Yeah.
So that's against the rules, the law of war.
And what about forcing population to displace?
Well, that's quite the contrary. Otherwise, you kill them. So this
But
is
still,
the way to deal.
Isn't it illegal to force
Ethnic cleansing?
This isn't ethnic cleansing. What they were trying to do to us was ethnic cleansing. I mean, we don't have a choice. In fact, the Trump program now to
incentivize them.
Incentivize the people from Gaza to move to somewhere else. For a similar thing, Fridtjof Nansen, a discoverer of the North Pole, a Norwegian, he got the Nobel Peace Prize, for what? After the First World War, at the end of the First World War, Greece was promised that it will become sovereign of the ancient parts of Greece, which are on the part of Turkey of today. They were part of the Ottoman Empire. Now, what happened was that at the end of the war, none of the allies came to help Greece there. And Venizelos, who thought that the allies would keep their promise, was bitterly disappointed because Ataturk displaced the Ottoman high port. He not only did he send the Greek army back, defeat the Greek army, he also set fire to Smyrna, Izmir, where there were hundreds of thousands, and other places where hundreds of thousands of Greeks had been living there since generations, since time immemorial, if you want. And about 600,000 Greek people were sent to Greece, were expelled to Greece, in fact, by force. Came Fridtjof Nansen and said, what should we do about this? And he not only had the plan, he also brought the financing to expel hundreds of thousands of Turks who had been living in Greece since generations to Turkey. So for completing the exchange of population, he received the Nobel Peace Prize. And the Norwegians are very proud of him to this date. Now, what happened in the Arab-Israeli conflict? Israel of my childhood was full of refugee camps. We called them ma'abarot. Jews from 600,000 Jews from all Arab states were expelled to Israel by force. And also, of course, the Jews from Europe came, and tiny Israel absorbed everybody. We don't have any longer any refugee camps.
Yeah, but we didn't exchange anybody in return, unfortunately.
The special thing is that the Arabs refused to take in their refugees.
Yeah.
This is the normal thing, is that each side look at India, Pakistan, and so on. So the unique thing, and the second unique thing is about our conflict is that the United Nations excluded these Palestinian refugees from the Refugee Convention. It doesn't apply to them. No state has to accept them. And instead created from them UNRWA, which turned out to be a terror organization, which itself advocates and educates children to become terrorists.
And creates a perpetual inherited refugee status.
Which doesn't exist anywhere else. There is no inherited refugee status, and the time has come to fix this problem. And I hope that President Trump will get the Nobel Peace Prize for that.
So I want one last, should Israel take pride in the fact that we are not only abiding by international law, but we go the extra measure? Should we take pride in that? Or should we be ashamed of ourselves that we're going so far? And in Hebrew, there's the sentence, "Mitachzer al Rahman al achzarim, sofo litachzer al Rahmanim." Right? Are we being too empathetic, suicidal empathy, as God? What's his name? Gadsar?
Well,
Gadsad?
we're Jews. So, I mean, that's what we are capable of doing. We don't behave like the Russians and the Ukrainians with each other. If you look at the numbers there, nobody complains there that they're doing ethnic cleansing of each other. You don't hear that. You don't hear about ethnic cleansing in Syria these days. Nobody, Giuliani, quite the contrary, he wore a suit, and now he is acceptable, caters to many European states. This is so. As Jews, we are measured differently, and we measure ourselves differently. I hope that we will at least be capable of reaching full victory, which we deserve and should have.
Amen.
Amen. Amen.
Professor Talia Einhorn, thank you so much for coming.
Thank you.
Thank you so much for having me.
Very
It's
interesting.
wonderful to be here with you.
Thank you so much.
Till next time, guys. Bye.
Bye.